Collection of votes commences at the registration area through ward level after voting, then it moves to the local government level, and then to the state collection center, and finally to the national collection center. It is after this that the winner of the election shall be announced. Furthermore, Section 60 and 60 of the Electoral Act deal with the counting and collection of votes cast. These provisions of the Electoral Act are very simple, plain, and straightforward, and do not require any technical rule of construction. The law is tried that where words used in a statute are clear and unambiguous, the courts are enjoined to interpret the words in their ordinary and natural meanings. Words used are to be interpreted in a way that will not clash with and defeat the manifest intention of the legislation. Every legislation is scripted by the lawmakers with a purpose. The court must be careful not to interpret the law so as to create absurdity or make nonsense of the law. See the cases of Imano and others versus Anekwe and others, Jegede and Anek, Guma and versus APC and others, Lado and another versus Masari and others. The law as prescribed in Section 60 and 62 of the Electoral Act 2022 does not in any form or sense make any provision or pretension as to any form of counting and collection of election results other than manual collection. In Oyetola and Anik Supra, the Supreme Court, per Agim JC, held on transmission of results, the essence and status of the collection system and the Anik RF portal as follows. Court, as I had held herein, there is no part of the Electoral Act requiring the presiding officer to transmit the accredited voters in the polling unit or the polling unit results during election to the Anik database as part of the election process. As stated in Section 62(1) of the Electoral Act 2022, after the recording and announcement of the result, the presiding officer shall deliver same along with the election materials under security and accompanied by the candidates or their polling units, polling agents, where available to such person as may be prescribed by the Commission. This is to enable the Commission compile, maintain, and update on a continuous basis a register of election results. This intention is clear from subsection 2 of Section 62, which provides that the Commission shall compile, maintain, and update on a continuous basis a register of election results to be known as the National Electronic Register of Election Results, which shall be a distinct database or repository of polling unit by polling unit results, including collected election results of each election conducted by the Commission in the Federation, and the register of election results shall be kept in electronic format by the Commission at its national headquarters. As their names depict, the collation system and the ANEC result VIM portal are part of the election process and play particular roles in that process. The collation system is made of the centers where results are collected at various stages of the election. So the polling unit results transmitted to the collation system provides the relevant collation officer the means to verify a polling unit result as the need arises for the purpose of collation. The results transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results on the election day. It is clear from the positions of Regulation 38(1) and 2 that the collation system and result viewing portal are different from the National Electronic Register of Election Results. The collation system and result viewing portal are operational during the election as part of the process. The National Electronic Register of Election Results is a post-election record and is not part of the election process. With this state of the law, let us now assess the case of the petitioners in this petition. The petitioners, as earlier mentioned in this judgment, are claiming that the failure of the first respondent to upload the election results constitutes non-compliance to the Electoral Act. They pleaded in paragraph 14 and 15 of their petition. Thus, reproduce paragraph 13 and 14. So the petitioners, by this pleading, are relying on the summary of final collation and declaration of results, which are in forms ECDA, in bracket, EC8E, as issued by the first respondent. The issues generated on this were not about the scores, but the alleged invalidity of the scores and the error of calculation of the scores. This pleading was not admitted by the first respondent. In reply, the first respondent joined issues with the petitioners in paragraphs 9, 10, 11 of their reply filed on 11 April 2023, which paragraphs are reproduced. It is settled law that issues for trial by the court are joined in the pleadings, and that parties and indeed the court are bound by the pleadings of the parties. The petitioner's case stands to collapse if no evidence is called on the issue. See the case of Uruwari and Osla and Nada versus Dixon. In the instant case, the petitioners anchored their case in this issue, on the report of the statistician, forensic examiner, and other experts. The statistician's report referenced by paragraph 14 and 15 of the petition was tendered in court through PW 21, Mr. Samuel Oduntan. It was filed on 14th of June 2023. The statistician's report was tendered, admitted, and marked exhibits PAH1, PAH2, PAH3, and PAH4 respectively. This report was challenged by the respondents, and in our earlier ruling, we came to the conclusion that it was incompetent and liable to be struck out, and was in fact struck out. Without prejudice to that ruling, I wish to assess its value. Nevertheless, PW 21, the maker of the said reports, was cross-examined in court by all the respondents, and he showed clearly that he is an unreliable witness. He was contradicting himself on issues around his report, apart from the fact that this witness is a subpoena witness whose witness statement of oath was not front-loaded. He did not present himself as a credible witness. Hear him under his cross-examination by Mahmoud SN for the first respondent. He said, I have formal training in information technology, IT, as stated so in my written statement. I was commissioned by the petitioners. I was compensated by the petitioners for my work. I am an expert in statistics. Apart from what I stated in paragraph 5 of my witness statement, I have enough experience in my work and election petitions. One does not need to be an expert to read INEC Forms EC8S. I commenced my work sometime in April. It took me about a month to complete my assignment. I cannot recall any proceeding where I admitted that I am not an expert. I agree that if my primary data is defective or incomplete, my conclusions could not be wrong or incorrect. I could be wrong or incorrect. I also agree that if my methodology is wrong, my conclusion will be wrong. I have seen page 4 of Exhibit PAH1. That page refers to the methodology I use as referring to Forms EC8S. I inspected the Forms EC8S at the ANIC headquarters. I do not know if those Forms EC8S are before the court. I am aware that the Form EC8S are stored in the various state headquarters. If what I stated in paragraph 2 at page 4 of Exhibit PAH1 is wrong, my conclusion will be wrong. I have seen column 1 of volume 3, Exhibit PAH4, at page 1, line 1. It refers to polling unit 009, ward 6 of Anambra State. When cross-examined by Chief Olani Pekun SN for the second respondent, the PW 21 said, I have seen paragraph 5A of my written statement on oath. It is true that I did not present the report in Khalil and Yaradua. I agree that no pictorial images of the electoral documents I referred to in my statement are attached to my statement. I am aware that PDP won the election in Adamawa State. By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I am not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the Situation Room of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH2. Furthermore, in response to the cross-examination of the Learned Senior Counsel for the third respondent, Fabian SN, the PW21 said, "It is true that I have been following ANEC activities since 1999. There was a time that ANEC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANEC chairman announce 2 days to the election that due to security and cash crunch, elections will not be possible it will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. I stated the role played by each of those persons. I have seen volume 3 of my report. They said volume 3 of my report deals with ANEC documents which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I'm aware that BVAS machine was used for accreditation. I'm the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It is in the instant case, it has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that Form EC8A series were altered and were not signed. It also talked of 15,002 polling units, where Form EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several forms EC8A series had a lot of alterations and that they were not signed by the presiding officers. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature from stamp and any alteration on the forms. Since PW21, who authored Exhibits PH3 and PAH4, did not place this in his report, and the petitioner did not call any of the polling unit agents to testify and place the forms before the court to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not proved as required by the law. On petitioner's allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submissions of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153F(1)(f) of the Constitution, and part of its functions as stated in paragraph 15, item F, part 1 of third schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) states that a collation officer or return officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that a number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47(2) referred to in Section 64(4)(a) relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, subparagraph 4b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 of Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot in a manner as prescribed by the Commission. The Act also provides in Section 60, subsection 5, that the collation officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collection is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or returning officer will use to verify and collect the results, subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or returning officer will use to determine the correctness of disputed result where there is a dispute. These are the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, Sub 2 of this Act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 60, Subsection 4 of the Act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in Section 61, transfer in Section 65, and transmitted directly in Section 50, Sub 2, 64, Sub 4, 5, and 6 of the Electoral Act in stating how results of elections should be handled under those provisions. A look at the definition of those words in the Black's Law Dictionary, 6th edition, show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the result of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, subsection 1 of the 1999 Constitution, and Section 148 of the Electoral Act 2022 that the first respondent herein made the regulations and guidelines for the conduct of elections 2022, as well as ANIC Manual for Election Officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation on non-compliance on paragraph 38, 1, Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and paragraph 93 of the regulations and guidelines. Paragraph 38, those provisions refers to have been reproduced in this judgment. So from the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 62(1) for the delivery by the presiding officer of the result, along with other election materials under the security and accompanied by candidates or their polling agents, were available to such persons as may be prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area from vote collation officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or his fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. And storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the annual result viewing portal, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area from vote collation center. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the result viewing portal, RF, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that INEC Results Viewing Portal, RF, is not a collection system. Thus, the Supreme Court in Oyetola and INEC has explained the difference between the collection system and RF, where Ajim JSC held as follows. As their names depict, the collection system and the INEC Result Viewing Portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of elections 2022, and the INEC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials under security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines, as well as the INEC manual, also state that hard copies of election results shall be used for collation, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists that electronically transmitted results or results from the INEC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that is substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instance case, from the myriad of decisions, the onus is directly on the petitioners not only to establish that through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another versus INEC, Audu and INEC, Oke versus Mimiko, Kente and Ishaku, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This Section 66 and 68 of the Act, which have been reproduced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the president as in Section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collation and announcements of results, signing of result forms, and publication of results. The results sought by the reliefs sought by the petitioners are declaratory in nature. It is cited in law that where a petitioner seeks declaratory reliefs, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondents or defendants. See Omishore and Arebeshola and Oga versus Ipiazu. It is also the law that the pleading and the claim of the petitioners determines the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the Commission of a crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, must be proved beyond reasonable doubt. See the application of this provision in the cases of PDP and INEC, IG versus PDP and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 2022 and an allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is simply non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probabilities. But the standard of proof in any ground that is primarily on corrupt practices would require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case, and on the issues being resolved here, the petitioners tendered some documentary evidence directly from the bar. The objections to the admissibility of most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioners called two star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Ta, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131 to 160 of the petition. In paragraph 23 and 30 of his sworn deposition, Dr. Ta, that's PW19, said as follows: I know that on the face of the form EC8D, 8 in A in bracket, there are calculation errors as shown and contained in the report of the statisticians, which the petitioners shall rely upon. The non-compliance consists of refusal to authenticate all the intending voters in the election using the technological electronic device prescribed by the first respondent, in addition to failure of the first respondent to transfer the outcome of the election directly into the portal of the first respondent created for the viewing of the public as a means to ensure the integrity of the election at the polling unit, and the electronical collation system before the declaration as to who is the winner of the election. There are no particulars supplied in his statement on oath. All that can be read from this statement are predictions without substance. When he was cross-examined by A.B. Mahmoud SN, he said that it is true that I am a lawyer and politician. I am the national coordinator for the petitioners. I was at the National Collation Center. I was throughout okay, it's up to here. Well, the cross-examination of that witness has been reproduced. It's a bit the sworn deposition on oath of the next star witness or the petitioners, PW22, Senator Delo Melai, is almost a rehash of the entire petition. What he said on cross-examination by A.B. Mahmoud has also been reproduced. The testimonies of these star witnesses under cross-examination aggregated the same account given by other witnesses that the election went well. Accreditation with the Vivas device was all right. The agents of the petitioners were on ground at the polling units, and that the results were entered on forms EC8S and duplicate copies given to the agents. The facts elicited from the cross-examination of these witnesses have belied much of the strands of their written statements on oath. This, of course, is a challenge to the credibility of the evidence of PW19 and PW22. While cross-examination has the capacity to tarnish the credibility of a witness, it also has the corresponding capacity of strengthening the case of the opponent. In the instant case, the evidence elicited from the PW19 and 22 on cross-examination has fortified, in my opinion, the case of the respondents that there was nothing wrong with the results of the 2023 presidential election and that there was substantial compliance with the Electoral Act 2022. That also played out in the cross-examination of PW20, Olatunji Oshele. His deposition on oath is at pages 204 to 207 of the petition. That is the same trend in the account of these witnesses. They were majorly giving account of not only the polling stations they voted, but other places not within their reach. The significant tone is that they testified of casting their votes without any problem. The results by their admission were properly declared and taken to the vote collation centers. The irony though is that the witnesses, is it okay? The irony, though, is that the witnesses did testify to a peaceful and valid election in their polling units where they voted and then turned around to give evidence of alleged infractions in polling units where they were not present. Their testimonies in that respect are hearsay. Hearsay evidence is not admissible and has no value in proving the petition filed by the petitioners. Furthermore, in the instant petition, first respondent consistently maintained that the technical glitch that occurred on the election day was the failure of the e-transmission server to upload polling unit results for the presidential election into the IRF portal. It claimed that the glitch only prevented the members of the public from viewing or assessing the results that were already uploaded and listed on the first respondent e-transmission system. On their part, the petitioners asserted in their petition that the glitch claimed by the first respondent was actually a bypass by the first respondent to tilt and switch the results of the presidential election in favor of the second and third respondents, as pleaded in paragraph 40. In furtherance of that assertion, the also pleaded in paragraphs 41 and 42 of the petition as follows. The petitioners applied to the court for subpoena to issue to the witnesses listed in paragraphs 41 and 42 of the petition on 26/5/2023. These witnesses were not called by the petitioners, and no reason was given as to why they backed down from calling the witnesses they pleaded to call in proof of their petition. It is tried that litigation, particularly election dispute litigation, is fought on pleadings. Parties swim or sink with their pleadings. For this, see the case of Anyafulu and others versus Meka and others. See also Ifeanyichukwu Osondu Company Limited and another versus Ahibe. Those pleadings in paragraphs 41 and 42 of the petition, having been abandoned, are discountenanced. In the same vein, paragraph 96 of the petition averred that agents of the second and third respondent disrupted the election. Votes scored were not accurately recorded, and that ballot papers were torn. The petitioners averred that video recording shall be tendered. However, the video recording was not tendered in that regard. In this respect, the presumption in Section 167D of the Evidence Act 2011 that they withheld the said video recording because it will be against them if tendered shall also apply. From the foregoing, therefore, it is very clear and certain that the petitioners have failed to prove that the 2023 presidential election and return of the second respondent was invalidated by reason of corrupt practices or non-compliance with the Electoral Act 2022. This issue, that's issue 1, is therefore resolved in favor of the respondents and against the petitioners. Issue 2 is Issue 2 is whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, he having not secured one quarter of the total valid votes cast in the Federal Capital Territory, Abuja. This issue has been resolved in petition number 3, and we adopt our finding and conclusion in that regard in this petition. Which what? Issue 3 is whether the second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended to contest the presidential election held on 25th February 2023, having regard to the alleged order of forfeiture arising from drug-related offense, his acquisition of the citizenship of a country other than Nigeria, and presenting a forged certificate to the first respondent. I do not intend to reopen this issue, having already ruled on it while considering the preliminary objections of the respondents. I held therein that the petition did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and their efforts to remedy it through their replies to respondents' replies were belated and of no avail. That ruling constitutes issue estoppel, binding not only on the parties, but on this court, meaning that this court cannot depart from the earlier ruling. So this issue is therefore discontinuous. This issue is whether the second respondent was elected by majority of lawful votes cast in the, that's issue 4, yes. This issue is whether second respondent was elected by majority of lawful votes cast in the election, and first respondent was right in declaring him as elected. This issue covers ground 3 of the petition. The facts in support of this ground were pleaded by the petitioners from paragraphs 105 to 145 of the petition. The petitioners specifically pleaded in paragraph 106 to 107 as follows. The petitioners shall lead evidence at the hearing to show that A, the result of the election as announced by the first respondent The polling unit agents of the petitioners who were present in all the polling units around the country were not called to testify to any problem or difficulties in their polling units on the 25th day of February 2023 presidential election. That is fatal to the petitioner's case. Thus, in Belgore versus Ahmed, it was said by Taba JSC as follows in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the trial. He did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstances, was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 2856 of the 1999 Constitution as amended. That, however, does not diminish the petitioner or appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This position of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsifying it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification of election documents when it is so alleged, as pointed out in Belgole and Ahmed. See also the case of Waziri Ibrahim and Shagari and Buhari vs. Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in Section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complained of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issues of evidence of witnesses who were not polling unit agents. The collation agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. The interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, the otherwise potent adverbial word manifestly used by the legislator in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or the understanding plainly or obviously, evidently, close of court. This means for the petitioners to throw up their arms and say we need not call oral evidence in proving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of non-compliance. We have started this Oetolo and Anek for the JSC. From this authority, it is the law that where the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at these documents to see if they manifestly show any lack of compliance. These exhibits include the following: exhibits PG1 to PG3, which were the printouts of bimodal voter accreditation system, VIVAS, for Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ekiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Ondo, Oshun, Oyo Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara were admitted, though objected to. Exhibit PH1 to PH36, which were the annex data on number of registered voters and collected PVCs for the 2023 general elections for the states listed in the first schedule of documents as numbers 46 to 82 were admitted. The second schedule of documents was filed on 31st May 2023, and the documents listed here Surprisingly, the documents were dumped on the court without any witness linking them up with the specific complaints of non-compliance. It is settled law that despite the tendering of exhibits in proof of a petition, the onus of proving the case pleaded and for which the documents were tendered in evidence lies on the petitioner. In the instant petition, a lot of documents were tendered from the bar. When a party decides to rely on documents to prove his case, there must be a link between the documents and the specific areas of the petition. The party must relate each document to the specific case for which the documents were tendered. Failure to link the documents is fatal and catastrophic, as it is in this case. The Supreme Court, in the recent case of Tumbi Bido versus Anik, have cited the portions. In this situation, it is invariably correct that all the allegations raised in this petition have not been proved as required by our law. See Buhari and INEC, Part 12 JSC. It is also important to draw our minds to the fact that criminal allegations are usually and directly made personal. For allegations of crime to be proved against the respondents, it must be proved that they committed the corrupt acts or aided, abetted, consented to, or procured their commission. Furthermore, it must be proved that the corrupt practices substantially affected the outcome of the election. See Omishore versus Arebeshola. The law also places the onus on the petitioners to demonstrate by credible evidence that the alleged corrupt practice indeed occurred and that it affected substantially the outcome of the election. In that quest, the petitioners pleaded some states where the malpractice allegedly occurred. One of such states is Sokoto State. They placed PW19, PW21, and PW22 to prove the allegations that the first respondent cancelled results from 241 polling units in Sokoto State in respect of National Assembly elections in the state, but went ahead to declare results for the presidential election. The three witnesses, PW 19, 21, and 22, were not in Sokoto during the election. There is also no evidence tendered of the cancellation of results in any of the units alleged. PW 19 and PW 22, when cross-examined, said they were in Kogi State, where they voted, and later came to Abuja. The PW 21 is the statistician who testified of overvoting, non-signing, and cancellation of forms used, but he did not tender or show those compromised forms. The same occurred in their testimonies in Kano State, Kogi State, Lagos State, and River State. From the foregoing consideration, it is very clear that there was no credible evidence by the petitioners to prove the allegations of corrupt practices. Under this issue raised, the petitioners were asking if the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of lawful votes cast in the election. From the facts placed before the court, the first respondent declared the results of the election by which the second respondent was returned. Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, four issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the three petitions, number CA from PEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-23 are all devoid of merit, the petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected president of the Federal Republic of Nigeria. The parties in the three petitions are to bear their respective costs. So now I will call on my learned brother by immediate right to read his own judgment. Arrange it.
Thank you. Please sit down, sit down. Thank you, my Lord. I was privileged and privy to be part of the decision and the judgment elaborately given by my Lord presiding Honorable Justice Haruna Somani, and I'm in full agreement with the lead judgment as delivered by him in these three consolidated petitions, which are petitions number CAPEC 03-2023 and CAPEC 04-2023 and CAPEC 05-2023. I agree also with the consolidated rulings on the various objections and other interlocutory applications relating to the competence of witnesses and the documents tendered in the three petitions highlighted. I also agreed with the reasoning and the conclusions arrived at the rulings on the preliminary objections and the substantial issues raised therein. In any concluded election, there are bound to be a winner and losers. While the winner celebrates victory, an aggrieved loser may come before the court to ventilate his grievances. This is made possible by the Constitution of the Federal Republic of Nigeria, 1999 as amended, which in Section 6 thereof empowers the courts to determine disputes, including election disputes. It is well settled that an election petition by nature is an election petition. A lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal for the hearing of the election petition and for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the court. It is tried law that under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that the election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements on oath of witnesses. 3, copies or lists of every document to be relied on at the hearing of the petition. A petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall, used in this legislation, makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or that it is difficult to prove the same petition. In the instant case, the petitioner's pleadings were deficient, while they complained of non-compliance with the Electoral Act against first respondent. Their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these three consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment.
I will call on my land brother, my immediate left, to deliver his own judgment.
I have read the lead rulings and judgments of my learned brother, H.S. Samani JCA, in the above consolidated petitions. I agree with his reasoning and conclusion in each petition and adopt same as mine. I add a few words for emphasis. Petition number 3. Ground 1 of the petition is that the respondent was, at the time of the election, not qualified to contest the election. The first complaint under this ground is that the purported sponsorship of the second and third respondents by the fourth respondent was rendered invalid by reason of the third respondent knowingly allowing himself to be nominated as the first vice presidential candidate, whilst he was still a senatorial candidate for the Borno Central constituency. The controversy about the third respondent knowingly allowing himself to be nominated in more than one constituency was the subject matter in PDP against INEC and others, reported in 2023 LPELR 60457SC. The Supreme Court Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, in their concurring opinions, held that the third respondent, having withdrawn his nomination and personally delivered the notice of withdrawal to his party, fourth respondent in this petition, on 6 July 2022, he was no longer a candidate for Borno Central constituency senatorial election in his subsequent nomination as the vice president for the presidential election was not multiple nomination. The opinion of the Supreme Court of the Supreme Court, Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, is not a comment or observation made in passing. It is an exposition of the law on withdrawal of a candidate from an election and the allegation that the third respondent knowingly allowed himself to be nominated as the vice presidential candidate while he was still a senatorial candidate for Borno Central constituency. Concurring opinion forms part of the lead judgment, and it is meant to complement him by way of addition or an improvement on the issues resolved in the lead judgment. See Unwana against FCDA, Oloruntoba Oju against Abdurrahim, and both and others against Just Electricity Distribution Company PLC. Citations supplied. The Supreme Court, having rendered its considered and definite opinion on the validity of the nomination of the second respondent as vice presidential candidates of the fourth respondent, attempts to reopen the issue in this court is a misadventure. The second complaint is that the second respondent was at the time of the election not qualified to contest for the office of the president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483 on 4th October 1993. The contention of the learned counsel for the petitioners is that the order of forfeiture made by the court is a fine under Section 137(1)(d) of the 1999 Constitution of the Federal Republic of Nigeria. It is a settled principle of interpretation that when the words used in the provisions of the Constitution are clear and unambiguous, same must be given their plain and ordinary meaning, unless to do so will lead to absurdity. See Abegundi and other cases cited here. The context in which the word sentence is used in Section 137(1)(d) of the Constitution connotes formal pronouncement awarding punishment after conviction for an offense. Conviction is a finding of guilt after an indictment, arraignment, and trial. See Kole Osho against FRN, Mohammed against Olawumi, Modu against Federal Republic of Nigeria. Therefore, the words sentence, imprisonment, and fine used in Section 137(1)(d) of the Constitution definitely connotes only a punishment imposed on a defendant following an indictment, trial, and conviction for an offense. See Babangida Usman against the state. Citation supplied at 40 to 41. Sharif against Federal Republic of Nigeria. Citation supplied. In civil forfeiture or a non-conviction-based forfeiture proceedings, in civil forfeiture or non-conviction-based forfeiture proceedings, the government only needs to show by preponderance of evidence that the property is a proceed of crime or was used to facilitate a crime. Criminal forfeiture, on the other hand, is seizure of a property connected with a crime after obtaining conviction and as part of sentence or punishment for the crime. Civil forfeiture is not a conviction or verdict of guilt after an indictment, trial, and conviction. See Jonathan against Federal Republic of Nigeria, citation supplied, where the Supreme Court per Karas JSC considered the provisions of Section 17 of the Advance Fee Fraud and Other Related Offences Act and persuaded by the decisions of the various courts across the world, held that civil forfeiture is an action in rem embarked upon when the interest of the government is merely to recover the proceeds of unlawful activity. The court also held that an application for interim forfeiture of property that is not predicated on conviction of the owner of the property will necessarily be an action in rem, because it is the recovery of the property that the law aims at. A forfeiture order by a foreign court can only be accepted and recognized by a court in Nigeria for the purpose of Section 137(1)(d) of the Constitution, if it is made after an indictment, trial, and conviction, and properly proved as required by Section 49 of the Evidence Act. In addition, the conviction and sentence must be shown to have been a product of due process of law. Compliance with the process of law has to be determined by the procedure and standard set by Section 36, subsection 5 and 6 of our Constitution. The forfeiture order being relied on by the petitioners has not been shown to be a result of a process similar to the one set by our Constitution for a trial of a defendant for an offense. The appellant counsel relied on Austin against United States, citation supplied, and Teams against Indiana, decided on 20th February 2019. The forfeiture proceedings in the two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment such as fine for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money, after forfeiting the properties listed under forfeiture of assets, etc., certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, etc., certain persons decree number 53 of 1999 as punishment. From all the above, it is clear that a non-conviction-based forfeiture, being civil in nature and an action in rem, can in no way be equated with a sentence of imprisonment or fine imposed for an offense involving dishonesty or fraud or for any other offense to disqualify a person from contesting for election to the office of the President of Nigeria. An indictment, arraignment, trial, and conviction are necessary preconditions for disqualification of a person under Section 137(1)(d) of the Constitution. Grant 2 of the petition is that the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. The allegations are basically predicated upon electronic transmission of the election. a global reading of the Electoral Act 2002, particularly sections 47-2, 61-5, 62-1, 65-1-8, will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC Regulations and Guidelines for the Conduct of Elections 2022, the first respondent made provision for electronic transmission and physical stroke manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provide that at every level of collation, where any copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officials shall use duplicate hard copies issued to the Nigerian Police Force and agents of political party to collate results. It is therefore not correct that it shall not be possible to collate results of the election where results have not been electronically transmitted. By law, the INEC Regulations and Guidelines for the Conduct of Elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act. The Act prevails. See Odeneye against Efunuga, Yesom against Peter citation supplied. Section 134.2 of the Act. By Section 134.2 of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECAT at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers, so as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW12 stated that the petitioners believed they have won the election if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the result was still being uploaded on the IREF? So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW12 that the petitioners were from the onset engaged in a wild goose chase an inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW 12, the petitioners exercise that right and add 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral Act provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167, the petition must, as a matter of law, be dismissed. See Abubakar and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. CLLU, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that would do violence to the provisions of the Constitution and fail to achieve the goal set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of this Constitution, 14(1) and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs. Our constitutional principles of freedom, equality, and justice, democracy, and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. The principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution being urged on us by the petitioners is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality. I have had a preview of the reasons given in the lead judgment of my learned brother. I agreed with his reasoning and conclusion. I adopt same as mine. I hereby abide by the orders made therein. As for 05, I adopt my reasoning in respect of the third ground, and I also dismiss the petition. On the whole, I to dismiss each of the 3 consolidated petitions. I abide by the order made in respect of the petition in the lead judgment.
My learned brother by my extreme right, shall present his own judgment.
Long last.
There's still one more? Okay. It's not complete, we do know. I had earlier read in draft the rulings and judgments of my learned brother, Aruna Simon Samani, in these consolidated petition numbers CAPEPC 03, 04, and 05, 2023. I am in complete agreement with his lordship's reasoning and conclusions on all of them. First, for petition numbers PEPC 04, 2023, that is the Allied People's Movement petition, I am of the very fixed view that the issues agitated by the petitioner therein concerning third respondent's alleged disqualification by reason of matters connected to and surrounding his running mate's nomination and relinquishing of his earlier nomination by his party for the Borno Central Senatorial District having been settled on their merit by the Supreme Court in its judgment, in appeal numbers SCCV 501, 2023, in third and first respondents' favor therein, with the Apex Court even holding that the said issues did not disqualify them, that decision constitutes issue estoppel, being status defining, and so judgment in rem it binds every person, including non-parties to the suit, like the petitioner in petition number CAPC 04, 2023, C. Kotun, and Oyekomi, Soson, and Odemuyiwa. Furthermore, by the doctrine of stare decisis, it also binds this court. In fact, it will, in my humble opinion, amount to judicial heresy for this court to involve itself in inquiring by whatever guise into that same issue already settled by the Apex Court. Coming to petition number CA03, 2020, of Peter Obi and another versus INEC and others, and CAPC 05, 2023, Atiku Abubakar and another, again, I am of the very fixed view that the two sets of petitioners did not by any means discharge the burden on them of proving that the results of the presidential election of 25th February 2023, as declared by first respondent, were incorrect. Incidentally, their burden is even made heavier by the legal presumption that the votes of an election declared by the official organizing body that INEC is are correct, and it is for the person asserting the contrary to prove it, Buhari and INEC. See Buhari and INEC. Even their resort to first respondent's failure to keep its initial promise to upload poly unit results of that election to its result viewing portal IREV real time, which failure the alleged evidences election manipulation, does not help them. And specifically on this allegation of manipulation of election results, the point must be made that since it is their case that from the word go that the election results in issue were manipulated by first respondent in favor of second respondent, and specifically that the manipulation took the form of, quote, programmed failure of the technological device, machines, that is beavers, by first respondent by intercepting the results, quarantining, warehousing, and filtering such results before releasing them to the IREF portal. 2, INEC replacing its in-house IT expert at the 11th hour with a rogue staff, all in a bid to completely control, monitor, and filter data transmitted from the beavers devices to the electronic system. And 3, that Globacom, the internet provider for the beavers and electronic system, was also disconnected by first respondent to enable it to manipulate the results. With the petitioners in CA, that is the Atiku petition, even going further to undertake to call evidence to prove all those allegations. The burden of proof was on the petitioners to prove those assertions, and that is regardless of whether they are positive or negative. After all, it is they who would have failed in the case if no evidence at all was adduced in their petitions. See on that sections 131 of the Evidence Act, Buhari and INEC, Aladegbemi versus Fasomade, Elias and Disu, Dashi and another, Abrat and Railway, Northeast Railway Company. I have taken all this time in making this point because of the argument of both sets of defendants that they only made negative assertions in their petitions, when they alleged that there was nothing wrong with first respondents' transmission system and IREF, so they had no burden to prove it. That the burden of proof was on the respondents who they said positively asserted glitch in real-time transmission of their results. Petitioners who directly made manipulation of its e-transmission system by first respondent to favor second respondents, a pillar of their case, cannot be held to say it is respondents and not them that had the burden of proof in this case. Incidentally, that assertion of petitioners that INEC simply closed down or blocked its IREV and e-transmission system from the public to enable it to manipulate the election results in favor of second respondent also takes me directly to the more important question in the petition, namely, whether that allegation is even worthy of belief, given the results declared by INEC for them and the second respondent in the election. To answer that million-dollar question, I deem it necessary to resort to the probabilities arising from the facts of the case. That test, otherwise called the probability test, which test celebrated Judge Chukwudifu Akonne Oputa, JSC, always maintained, and I quote him, is the surest road to the shrine of truth and justice. See the cases of, he said so in the case of Dibia Amaka and others, and in Ojegele and others, the first 1989 and the second 1988. I gave the citations. Here, the assertion of petitioners is that first respondent, INEC, merely used the excuse of glitch in its IREF portal to block the public from seeing its polling unit results real time so that it could manipulate, and indeed actually manipulate, the 25 February 23 presidential elections in favor of second respondent. It is their further contention that the manipulation of IREC by INEC with the said phantom glitch in favor of second respondent was nationwide. The question is, do the results declared by INEC support that hypothesis? They say the taste of the pudding is in the eating. I shall therefore now try to walk us through some of these election results to see if that assertion of petitioners is supported by the results declared by INEC and so probable and worthy of belief. In doing that, I shall randomly pick on the results of some states of the Federation and the Federal Capital Territory. I shall be relying on the state summary of the results, that is from ECD, declared by INEC and has also attached their petition by the petitioners in CAPC 05, that is Atiku's case, which result was also tendered by both sets of petitioners and respondents. So I take first Abia State. There, second respondent, the alleged favored candidate of INEC, for which it was said to have shut down its IREV to manipulate results, only garnered a miserly 8,914 votes. That is as against the Labour Party, which by INEC's declaration polled as many as 327,095 votes. Even the other set of petitioners, complainants, the PDP and its candidates, scored more votes in Abia than INEC's purported favored candidate. They also scored 22,676 votes in Abia and was so recorded by INEC. Those votes alone are close to 3 times the votes of second respondent, for whom INEC was said to have manipulated results by closing down its IREF, so that the public would not witness its manipulative activities in favor of second respondent. In Enugu State, the same favored quote-unquote candidate, second respondent, was again declared credited by INEC to have polled only 4,772 votes in the entire state. Meanwhile, the Labour Party and its candidates were again declared by manipulative and quote-unquote and unfriendly INEC to have scored as much as 428,690 votes in that state. In the same Enugu, PDP and its candidates was also declared by INEC to have polled 15,745 votes, a number that is also nearly 3 times the votes of the so-called favored second respondent. In Anambra State, the same purported favored candidate, second respondent, was declared by his alleged friend INEC to have scored only 5,111 votes. Meanwhile, the Labour Party, whose candidate, first petitioner in CAPC, I must take judicial notice of, vide Section 124 of the Evidence Act, is from that state, again was declared to have polled as much as 584,621 votes. Again, like Enugu State, the PDP and its candidate was declared by INEC to have polled 9,036 votes, a number that is also nearly double the votes of, quote, INEC-favored, end quote, second respondent. In neighboring Delta State, the same INEC-favored candidate, second respondent, was declared by INEC to have scored 90,180 votes. That is as against the Labour Party and its candidate, which is credited by the same biased, quote-unquote, INEC, to have scored as much as 179,917 votes. In that same Delta State, the PDP and its candidates scored 161,600 votes, again nearly double the votes of second respondent. In Adamawa State of the PDP and its candidate, the same favored second respondent was declared by INEC to have scored only 105,648 votes, while the PDP and its candidate were declared by the biased, quote and unquote, INEC to have scored as much as 214,012 votes. In Imo State, the same purported INEC-favored candidate, second respondent, was declared by INEC to have scored only 66,406 votes, while the Labour Party and its candidate is declared by the same INEC to have polled as much as 360,495 votes. In Ebonyi State, the Labour Party again scored as much as 259,738 votes. That is as against alleged INEC-favored second respondent, who by INEC's declaration, that is his friend's declaration, again polled a relatively miserly 42,402 votes. The PDP is said to have scored 13,503 votes there. Even in Lagos State, where second respondent was once held sway as elected governor, the Labour Party and its candidate was again declared by bias, quote and unquote, INEC to have beaten second respondent with almost 10,000 votes. Labour Party was declared by INEC to have polled 582,455 votes as against 572,606 polled by second respondent and so declared by INEC. It is a similar story in the federal capital territory of Abuja, where INEC has its headquarters and supposedly carried out, directed, all its, quote, manipulative and biased activities in favor of second respondent that petitioners claim he did in the election. Second respondent and his political party still lost there. In fact, by the result, second respondent friendly, quote and unquote, INEC declared in the federal capital territory of Abuja, second respondent could not even make 25% of the votes, total votes cast there. He was said to have polled only 90,902 votes. That amounts to just 18.991% of total votes cast in the FCT, yet INEC declared that result. That is as against 281,717 votes, amounting to 58.856% of the total votes, the same INEC declared for Labour and its candidate. There are also other states, including Katsina State of the immediate past president of this country, a member of the second respondent, who was still in office at the time of the elections, in fact, as I take judicial notice of video section 124 of the Evidence Act. There again, second respondent and his party, the APC, also the then sitting president, was declared by the same INEC to have lost to the petitioners in CAPC 05-2023, that is Atiku Abubakar. Now, if all these results declared by INEC for each of the states for the two sets of petitioners, and second respondent is anything to go by, then INEC must be an abysmally poor manipulator, if not even an imbecilic one. Surely it would not go through all the stress of closing down its IREF and blocking the public from seeing its manipulative efforts in favor of second respondent, as alleged by the petitioners, only for it to still end up favoring the petitioners with jumbo votes and posting miserly figures for its favored second respondent. It is said that all men stamp as probable that which they would have said or done under similar circumstances, and as improbable that which they themselves would not have said or done under the same set of similar circumstances. Things inconsistent with human knowledge and experience are properly rated as improbable, end quote. See again Oputa GSC on this, in Onwa and the state and Bozin and the state. At any rate, why did any of the two sets of petitioners not tender even a single polling unit result issued by INEC to their polling unit agents to support their claim of manipulation of election results by INEC, even as they all agreed that they had agents in the polling units? I have thought that this is the best and most effective way of proving the manipulation of election results alleged by them. After all, the polling unit is the only place where voting takes place, and so also constitutes the building block of election results. That much is stated in paragraph 90 of INEC guidelines and for the election, and also Nwobodo and Ono and Awuse and Odele. In short, the allegation of the petitioners that INEC shut down its IREF to manipulate votes for second respondent just does not add up for me. If anything, the probabilities arising from the results INEC declared nationwide as S-rate above rather seem to me to eloquently support its position that its inability to upload the polling unit results real time, as earlier promised, was not deliberate but caused by technical issues outside its control that afflicted its e-transmission system, which issues it claims made it impossible for its e-transmission system to map the uploaded polling unit results for the presidential election to any specific state. That it claimed is unlike the much smaller National Assembly elections that were conducted simultaneously with the presidential election. It is that phenomena it describes as glitch that was giving it an HTTP 500 error, which eventually resultantly delayed real-time public viewing of the said polling unit results. That conclusion also takes me to another big issue in this case, namely the evidential value of the European Union Observer Mission report on the 2023 presidential election, over which quite a mountain has been made of by both sets of petitioners. That report was tendered by the petitioners in petition number PEPC, that is OB and another, as Exhibit X2, and by the petitioners in CEPEC 05 as Exhibit RA27. The impression given by both sets of petitioners is that the said report, which in any case has been even ruled admissible by us in petition number CAPEPC 03-2023, is like gospel truth of what happened in the election. And so it must be accepted by this court, and the conduct of the presidential election declared corrupt or at the very least below par, regardless of whether or not its authors presented themselves in court to defend their opinions. That stance, I am afraid, is a non sequitur. It's a complete non sequitur. Without the makers of that report presenting themselves in court to face cross-examination, to authenticate their opinions, that report, and I dare to add even the ECOWAS report of the same elections, tendered by second and third respondents in petition numbers in the two petitions, are completely valueless and inadmissible for the purposes of authenticating the opinions expressed in them by the makers. See first on that the cases of Nyesom and Peter Said and Said Yakowa. It also makes no difference that the said reports have been put in the form of print. Books, it must be noted, cannot be cross-examined. On this, I find support in the celebrated case of Idudu and others versus Okumagba, where the Supreme Court, 1976, where the Supreme Court had this to say, and let me quote what the Supreme Court said. It said, as for the law involved in Idudu and Okumagba, we would like to point out that it is now well settled that there are 5 ways in which ownership of land may be proved. In our view, not only was the evidence of the witnesses, that is continuation, not only was the evidence of the witnesses called by the appellants rightly rejected by learned trial judge for good and sufficient reasons, we also think that he was right in not attaching any weight to the views expressed in the book cited in support of such traditional evidence. As Lionel Brett JSC, as event was rightly in our view once pointed out in a learned address given by him at the University of Lagos to the Nigerian Association of Law Teachers, smaller quote again, the courts are not to be hypnotized by the authority of print. The crucial fact is that books cannot be cross-examined, either as to the opinions expressed or as to the claims of the author to have special knowledge. If the author is living, there is no reason why he should not be tendered as an expert when this difficulty would vanish. Small quotes, end quote of that side. Then the Supreme Court went on to say, moreover, none of the authors of these books in that Kumagba's case testified in support of the views stated therein, and no explanation was given for the omission. For all these reasons, we share the apprehensions of the learned trial judge about the value or weight of the traditional evidence as narrated by each of these authors, particularly as the authenticity and impartiality of the sources of their narratives cannot, for obvious reasons, be easily ascertained, end quote. I went on to say that is the exact same situation we are confronted with here as regards both the European Observer Mission report and its brother ECOWAS Election Observer report. For purposes of proving the opinions expressed in them by their makers, neither of them is of any higher value than the mere sheets of paper on which it is recorded. And for those who, like the petitioners, are enamored by the now very familiar patronizing judgments passed on elections, regularly passed on elections, by European election observer missions every 4 years, even as the same Europeans have maintained a deafening silence on the never-ending complaints of former President Donald Trump, that the year 2020,000 presidential elections of the United States that saw him out of office was also a fraud, it may interest them to know that Sir Justice Lionel Brett, who made the comment cited approvingly by the Supreme Court in Okumagba's case that I read above, was also a European. He's British. He was British. I think I intend to stop here. I think I've said enough. It is for these few additions, but much more for the far more illuminating reasons advanced by my brother Haruna Samani JSC in his rulings and judgments, which reasons I concur with without reservation, that I also hold all 3 consolidated petitions not proved and thereby enter another dismissing all of them, and I affirm the declaration of second respondent Bola Ahmed Tinubu by second respondent as the person duly and properly returned winner of the 25th February 2023 presidential election of this country and duly elected president of the Federal Republic of Nigeria. I also abide by all other consequential orders, including that as a cause contained in the leading judgments.
I now invite my learned brother by my extreme left to present his own judgment.
Well, last but not the least, I've read before now a draft of the lead judgment just delivered by my learned brother, Haruna Simon Samani, JCA, in the three consolidated petitions of CAPEPC 03-2023, CAPEPC 04-2023, and CAPEPC 05-2023. I'm in agreement with and I adopt all the reasons and conclusions stated therein, both in relation to the rulings on the objections and the merits of the three consolidated petitions. Although all the issues in petitions number CAPEPC 03 and 2023 and CAPEPC 05 2023 have been exhaustively resolved in the lead judgment, I deem it only pertinent to highlight a fundamental vice which has affected the two petitions, especially as it relates to the petitioner's essential contention or premise upon which they predicated those two petitions. In those two petitions, the petitioners have premised their ground that the presidential election conducted on the 25th of February 2023 is invalid by reason of corrupt practices and non-compliance on their contention that by the provisions of the Electoral Act 2022 and the regulations and guidelines for the conduct of elections 2022, the first respondent, INEC, is mandatorily required to electronically transmit election results to the coalition system and to the INEC results viewing portal, the IREV. They contended that the first respondent had deliberately refused to comply with those mandatory provisions and had manipulated the results of the election through various corrupt practices which they allege in those two petitions. However, in both petitions number PEPC 03-2023 and PAPC 05-2023, exhibits X1 and X2, which were tendered respectively to show that the Labour Party, the second petitioner in petition number PEPC 03-2023, had before the elections approached the Federal High Court Abuja for the determination that, and I quote, by the provisions of the Electoral Act 2022, INEC, the first respondent, has no power to opt for manual method other than the electronic method provided for by the relevant provisions of the Electoral Act, unquote. And I quote again, an order of this Honorable Court directing / compelling the respondent to comply with the Electoral Act 2022 on electronic transmission of result in the forthcoming general elections, unquote. In that judgment, the Federal High Court Abuja Division had dismissed the suit and held that, and I quote, there is nowhere in the above cited sections where the Commission or any of its agents is mandated to use an electronic means of collating or transferring of election results. If any, the Commission is only mandated to collate and transfer election results and number of accredited voters in a manner or way deemed by it. Additionally, this court's attention was referred to the judgment of this court in appeal number CA LAG CV 332-2023, APC versus Labour Party and 42 others, delivered on the 19th of June 2023, in which this court set aside the judgment of the Federal High Court, Lagos Division, in another suit number FHC LCS 370-2023, Labour Party and others versus INEC, filed by 8 Labour Party, the second petitioner in PEPC 03-2023, before the Lagos Division of the Federal High Court to obtain an order of mandamus compelling INEC to electronically transmit or transfer election results as provided in its regulations, after losing in the Abuja Division of the same court. In the judgment of this court of 19th of July 2023, in appeal number CA LAG CV 332-2023, this court particularly held at pages 23 to 24 thereof that, and I quote, it is difficult for suit number FHC LCS 370-2023, which gave rise to this appeal, to escape the label of abuse of court process. I said so because the objective of the suit is to compel the 43rd respondent to adopt a particular way of transmitting or transferring the results of the election in Lagos State. This objective is not in any way different from what the objective of the first respondent wanted to achieve in suit number FHC ABJ CS 1454 2022. Similar parties are the same in the two suits. The second to 42nd respondents are members of the first respondent, which litigated the suit number FHC ABJ CS 1454 2022. The second to 42nd respondent's interest is the same with that of the first respondent, so they are the first respondent's previous. Both suits are against the same defendant, that is the 43rd respondent hearing, and filed in the same court, albeit different divisions of the court. The decision of Emeka Nwite J of Abuja Division of the Lower Court, which dismissed the first respondent's suit, holding that on the interpretation of the provisions of Section 60, subsection 5, 62, subsection 2 of the Electoral Act 2022, INEC, the 43rd respondent hearing, is at liberty to prescribe or choose the manner in which the election results shall be transmitted, finally settles the issue. I therefore find in suit numbers FHC LCS 370-2023, which is herein being appealed against all the trademarks of the cause of an abuse of judicial process, unquote. Exhibits X1 and X2 tendered in petitions number 03 and 05 respectively, as well as the decisions of this court in appeal number CA LAG CV 332-2023 Supra, are subsisting judgments of court which are not only binding on the parties, but which constitute issue estoppel to the petitioner's essential contention in the two petitions, that the first respondent is by Electoral Act 2022 and the INEC regulations mandatorily required to electronically transmit and collate results of the presidential election. The doctrine of issue estoppel is that once an issue has been finally decided by a competent court, the issue will not be allowed to be relitigated by the same or even different parties. See Cotton versus Oekami and another, APC versus PDP and others, Ezewani versus Onwodi, citations on the record. Indeed, in Ezewani versus Onwodi, the Supreme Court, Pauputa JSC, specifically held as follows. Strictly speaking, therefore, the concept and value of an estoppel is to bar a person from denying or asserting anything to the contrary of that which he has, in the contemplation of the law, been established as the truth, either by the acts of judicial or legislative officers or by his own deed or representation, express or implied, unquote. It is clearly evident that the decisions in Exhibits X1 and X2 tendered in the two petitions, respectively, as well as the decisions of this court in appeal number CA-LAG CV 332-2023, APC versus Labour Party and 42 others, have dealt a death knell to the petitioner's contention around which they have built their claim of non-compliance and corrupt practices in those two petitions. Namely, that the first respondent is by the provisions of Electoral Act 2022 and the regulations and guidelines for conduct of elections 2022 mandatorily required to electronically transmit election results to the collation system and to INEC result viewing portal, which is the RF. Apart from this fundamental deficiency, which I have highlighted, the lead judgment just delivered had exhaustively considered all the other issues and rightly concluded, in my view, that the petitioners in petitions number CA-PAPC 03-2023 and CA-PEPC 05-2023 have failed to establish all the allegations contained in the two petitions. I adopt all those reasons and conclusions stated therein and also find the two petitions devoid of merit. Petition number 04, as regards that petition, the petitioner has, under the guise of challenging the qualification of the third respondent to contest the presidential election on the ground that he had violated the provisions of Section 142, subsection 1 of the Constitution of the Federal Republic of Nigeria 1999, basically challenged the validity of the nomination of the fourth respondent by the third respondent as his running mate in the 25th February 2023 presidential elections. In concurring with the lead judgment just delivered, I also hold the considered view that the status of the nomination of the fourth respondent as the running mate of the third respondent and vice presidential candidate of the second respondent had been finally decided by the Supreme Court in appeal number SCCV 501-2023, PDP and INEC, delivered on 26th of May 2023, now reported as PDP and INEC and three others, 2023 LPLR 60457 SC, the certified true copy of which was tendered as Exhibit X1. In the concurrent judgments of their lordships, Okoro, Augi, Ogunwumiju, Agim, justices of the Supreme Court, they have all determined as proper the nomination of the fourth respondent as vice presidential candidate of the second respondent. As for the petitioner's argument that the pronouncement of the Supreme Court in those concurring judgments is an obiter dictum, the clear statement of Ogunwumiju JSC has left no one in doubt that the Apex Court decided the merit of that case. My Lord Ogunwumiju JSC clearly stated at page 74, paragraph C of that judgment that it is apt in this type of political case of public interest to look into the merits of this case, unquote. It is settled law that once the issue relating to the status of a person or a thing is finally and substantively determined by a competent court, such a determination constitutes estoppel to any subsequent proceedings on the same issue. See APC, PDP, and others, Inakoju and others was the delicate citations on the record. Now, for all this, and all the detailed reasons succinctly stated in the lead judgment just delivered, I also hold that this petition is lacking in merit. Having also found that no merit exists in all the above three consolidated petitions, I join my learned brothers Amani Jessie in dismissing all the three petitions and abiding by the consequential orders made in the lead judgment.
Well, with the judgment delivered by my learned brother Abba Mohammed, we have discharged our responsibility to the nation. We have concluded the hearing of this petition and we have concluded the delivery of the judgment. So we thank the Almighty God for bringing us this far. All these months, both counsel in all the petitions have labored, they have tried to represent their clients creditably. And we thank you for their assistance because their assistance have helped us to reach our conclusions in this judgment. So as we leave today, we hope that very soon, both us and counsel will meet in our normal cases. Yes. These cases have tended to put a distance between us. But when we resume in our normal cases, we shall see and interact better. Thank you and God bless us all.
Thank you very much, my lords. On behalf of the petitioners, with all sense of responsibility and urgency, there's a little request we want to make, given our severely limited time by the practice directions to exercise our constitutional right of appeal. We will request, because our time starts running today, if we can have the copies as we leave today, so that, because any day that we lose depletes our right. We know the day is far spent. It's our humble request, so that the registry, once we leave, will be able to collect from them. We are very grateful, my lords.
Well, I am sure learned senior counsel is aware of the time now. It's 10 o'clock now. And, well, it's unfortunate. We understand your constraints, but you have to bear with us to tomorrow. Yes. Hopefully, you know, the judgments are a bit bulky. It's a consolidated judgment. We have to put
tomorrow we can have them from.
Yes, we have to put everything together, bind them, and give it to council.
We are very grateful.
Yes.
Tomorrow, my lords.
So we thank you for all the efforts you have put in. Thank you. Forget now.
My lords.
So, a day.
Yeah, sorry, my lord. I know the day is far spent. I thought my senior colleague will actually thank my lords for the industry put into this judgment. It is a well-considered judgment, and these judgments will no doubt change the face of our electoral jurisprudence. We have traveled this part of history this past few months, and today we have reached the end of it. We pray that that we all learn from it. We have all learned from each other during the course of our stay here. We salute you, my Lord, for the clear, detailed review of the pleadings, the issues, and the evidence in the petitions, especially on the issues surrounding technology. That was an area we thought we were going to have problems.
Please be brief.
But we thank you, my Lord, for this judgment, and we are very grateful. Thank you. God bless you, and God bless the Federal Republic of Nigeria.
Yes.
Well, my lords, mine is a short one. I thank your lordships. I think earlier on, my lord, there was supposed to be a misunderstanding. I apologize for that. It wasn't the intention at all. I appreciate your lordship's industry, and this work is not easy. I don't think I could have done any of the jobs your lordships did this evening. From 9:30 till now, I would have lost my voice. But I thank your lordships, and I pray that the bar and the bench continue to have a good relationship in all things. Thank you very much.
So, you are still...
Sorry, my lord.
Yes, I think...
My lord, I'm very sorry.
Well, we know, we thank you also.
Sorry, my lord.
Yes, we thank you for...
No, my lord, I just have one or two things to say.
You are who? Who are you?
My lord, I'm counsel to the second and third respondents. Malik.
Malik?
Yes, my lord.
Oh, okay.
Okay, thank you, my lord. My lord, I'd just like to also register my appreciation for our appreciation. And I do this, my lord, with every sense of responsibility. And on behalf of our leader, Chief Wole Olanipekun, Senior Advocate of Nigeria, who is unavoidably absent. My lord, I'd just like to say that I have listened to several judgments emanating from the world of the soul of this court. None of them ranked top as this one in terms of industry, scholarship, and all good things that we have seen evident and are on offer in this judgment, consolidated judgment delivered by the laws. I think it is now time that my Lord take your deserved rest. We wish you good health, my Lord. God bless you all.
No, call the court, please.
You are on to the network service of the Nigerian Television Authority. For the past 12 and a half hours, we have been having a special coverage of the sitting of the Presidential Election Petition Court, which delivered its judgment on the petitions filed against the election of Bola Ahmed Tinubu as President, Commander-in-Chief of the Federal Republic following the February 25th, 2023 elections. So it's been a long day, and I'm sure that for the only 15 minutes or so break that the 5 justices of the petition court had, they've sat for the past 9 hours without rising. And so we're back to the studio here. Our correspondent, who is the head of our judicial desk, is still out there, and we're trying to establish contact with him to give us a feel of the ambience as the court has risen. I'm talking here about Dele Atumbi and also, of course, Austin Ayebe, who both have been on the matter with us from the, Austin Ayebe, who both have been on the case since their lordships began sitting at about 9:30 this morning. So back to the guests that we've had. I must appreciate the first two guests who commenced to this transmission with us. Professor Edoba Morige, he's still here in the studios 12 and a half hours later. And of course, Ezewa Wago is still also with us. We had another guest who joined us and has been around for the past 10 hours, I imagine, 9 hours. And he's Dr. Sijuade Kayode. Is another legal practitioner. So I'd like to welcome you, Sijuade, to the conversation segment, as it were, of our special coverage of the sitting of the Presidential Election Petition Court. As we say in law, that court is now functus official. In other words, it has performed its assigned constitutional role, acting as a court of first instance.
Cac TV, igniting the apostolic fire. 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 Cac TV, igniting the apostolic fire.